Titus Wambua and Eric John. So this is the ruling. Oh, sorry, let me just get the quorum. Yes.
I remain Felix Keaton for the 6th, 4th, 5th, and 16th respondents. And I also appear alongside my friend, Ms. Maricha.
For purposes of record, my name is Sonny for this.
Your Honor, if it pleases you, a year for the first respondent.
Mr. Ayeko for
Fourth.
So I think I'll read this ruling in brief. I may not be able to read the entire ruling. Before the court is a notice of motion, application dated 5th of August, filed by the state against the 6 respondents herein. The applicant seeks 2 orders. The first being continued detention of the 6 respondents at Muthaiga police station for a period of 30 days, working days, to enable the Directorate of DCI officers to complete investigations, and 2, that the court makes any other orders that it deems fit to grant. The application is supported by an affidavit sworn on 5th of August by the IO, Detective Corporal Nicholas Osuri, an investigator attached to Land Fraud Investigation Unit, and the 26 grounds set out on the face of the application. So a brief background of the application is that the applicant had moved this court via a miscellaneous application, the same miscellaneous application dated 1st of August 2024 for search warrants, which orders were issued by the court and executed, leading to the arrest of the respondents herein. So the court had the submissions by both parties, that is the investigating officer and the prosecutor on behalf of the state, and the counsels appearing for the respondents. So I've analyzed the submissions that were made by the parties, but I'll not go to the details, but I want to go straight away to the determination. So the court has considered the application by the state, the response by the respondents, and it is settled law that that an arrested person has the right to be released on bond or bail on reasonable conditions pending a charge or trial, unless there are compelling reasons not to be released. In Republic versus Danford Kabage, which was cited by the respondents, the court provided the test of determining what constitutes compelling reasons, and held that compelling reasons grounds ought to be proved to the satisfaction of the court, and that mere allegations or possibility is not enough. The court held that a bail cannot be refused simply because the accused has been charged with a very severe charge. It is also settled law that the burden of proving to the court that there are compelling reasons rests on the prosecution. The High Court, in the case of Oscar Kipchumba versus Republic, held that in order to succeed in an application of this nature, the state must satisfy a double test. Number one, the state must persuade the court that it is acting in absolute good faith, and that the continued detention of the individual without a charge being preferred is inevitable due to existing exceptional circumstances. Secondly, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interests present in a potential criminal trial, and that is the rights of the arrested individual, the public interest, order and security, the need to prevent the integrity of the administration of justice, and the interests of victims of crime where applicable. The court held that by virtue of Article 21, 1 and 259 of the Constitution, the court must act to aggrandize, not to diminish, the personal liberties of arrested individuals, in line with the other three interests. Or differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail while balancing all factors within the complex permission presented by the quadruple interests. The question then that this court must look at, or which arises here, is can it be said that the state is acting in absolute good faith, and that the continued detention of the respondents herein without a charge being preferred or pending conclusion of investigations is inevitable due to existing exceptional circumstances? The state's grounds of seeking the detention of the respondents were laid down in the affidavit sworn by the investigating officer, and the court will consider each of them to see whether they are compelling reasons. So I will first list all the grounds, which are: number one, the investigating officer indicated that he sought more time to verify or trace the registered owners of title deeds which were recovered, and the lease certificates through the State Department of Lands. Number 2, he sought more time for verification of security features on the recovered lease certificates and the title deeds. 3, for verification of authenticity or originality of the imprinted names on the recovered stamps, which had the names of land registrars, administrators, land surveyors, advocates, etc. 4, he needed to do further forensic examination of the gadgets which were recovered, like laptops, phones, flash disks, desktops, CPUs, printers, etc. 5, to pursue unknown persons who the respondents were sharing images of various copies of land registration documents, including certificates of lease. And the last one, to investigate properties which include assets, financial transactions, and the dealings by the respondents relating to the recovered documents. Grounds number 1 to number 4 above, in my view, are related, and therefore I will combine them. The state is simply saying in these grounds that they collected a number of documents and gadgets which need to be examined forensically. It is noted that the investigators had earlier approached this court and sought orders to enter and search the respondents' premises and to take away documents and electronic gadgets of interest. The report furnished to the court after these orders have been given is that the investigators successfully did so and impounded the items. The question is it then necessary to have the respondents in custody in order to verify and carry out the forensic audit of this howl? The court does not think so. The respondents are not in control of the forensic lab that will be used to conduct the forensic audit. Neither do they control or work for the agencies that would be verifying the court document, the recovered documents. No evidence was tendered to show that the respondents are capable of interfering with the verification process, and therefore my finding is that this ground 1 to 4 above are not compelling reasons. As regards ground 5, which is that the investigators wish to have more time in order to pursue other people to whom images were shared by the respondents. It was not clear from the affidavit or from the submissions by the prosecutor who among the 6 respondents shared the images and to whom or which phone numbers they were shared. It was also not clear how the detention of the 6 would help in tracing the said people. It is not clear how the detention of the 6 could help in tracing the said people. So my finding is that this also is not a good ground or not a compelling reason. The final ground, which was ground number 6, was that the investigators wanted to investigate properties including assets, financial transactions, and dealings relating to land registration. Once again, apart from stating what he intended to do, the investigating officer did not state how the remand of the respondents for 30 days would help in investigations, or how the release of the respondents would prevent him from carrying out that part of his investigations. The court therefore finds that the threshold had not been met. The court concludes by stating that criminal liability is personal. The investigating officer in this case did not present to the court information related to each respondent and why it was necessary for each respondent to be denied bond. The investigating officer treated the respondents as an entity instead of separate individuals whose criminal culpability will ultimately be determined individually by the court. I am not convinced from the grounds given that I'm not convinced that the grounds advanced herein in a bid to secure the custody of the respondents applied to all the respondents. In fact, from the affidavit, there is nowhere the investigating officer has mentioned anything regarding the arrest and the grounds of arrest of the 5th and 6th respondents in this matter. It was evidence. It is evident that information was not obtained in relation to each respondent to determine whether the circumstances of each applicant constituted a flight risk or the likelihood of interference with witnesses. The prosecutor made some submissions that the second respondent had swallowed a memory card and at the time of a memory card at the time of arrest, and that the police the arresting officers sought services of the anti-narcotics unit at JKIA to try and help in retrieval, which efforts were in vain, and that he will be seeking to have him taken to Kenyatta National Hospital for examination. The court finds that this to be an exercise in futility, considering that since the date of the arrest of the said suspects, a period of maybe of around 3 days, the said respondent had not been under observation, and anything could have happened in between. It is a finding of this court, therefore, from the above, that compelling reasons have not been given to deny the respondents their bond as provided for under Article 49(1) H of the Constitution. The following, therefore, is the disposition of the application. Each of the respondents shall be admitted to cash bail of Kenya shillings 500,000 with one surety of with one contact person, 500,000 shillings cash, that is cash bail, with one contact person each. The respondents will be reporting to Land Fraud Unit of the DCI 2 days a week, that is Mondays and Thursdays, until the DCI officers decide to charge or discharge the respondents or until further orders of the court. The respondents are hereby prohibited from contacting potential witnesses or interfering with any investigations that are ongoing. And the matter will be mentioned on 10th of September 2024.
Much obliged, Your
So
Honor.
that is the ruling of the court.
Much obliged, Your Honor. We are grateful on behalf of the respondents for the robust decision. We will humbly be requesting for a appropriate decision for our records. We are grateful, Your Honor. Thank you, and have a good day.
Your Honor, I have a small application to make
Yes.
on behalf of the fourth respondent
Yes.
that some of the documents which were confiscated is his wallet, and the wallet contains medical cards for the family. There is nowhere where they have deponed in the affidavit that they would require the wallet and the medical covers and Kenya shilling 19,000, which was in the wallet. And since the fourth respondent is the sole breadwinner of his family, we are requesting that said wallet be released to the family members. You're most obliged.
Prosecutor.
Please, Your Honor.
Yes.
I was just consulting in relation to that application. I will not be opposing the application to release the wallet and the documents that have been mentioned. However, I've also been instructed to bring to the attention of the court
Yes.
concerning the memory card that was swallowed by one of the respondents. The instructions are to inform the court, though I don't have not been given an official document, that the information the investigating officer has is that it has stuck in one of his intestines. I was struggling to get more information.
Your Honor, we will humbly object to that in the application. The court has made the decision, unless they can file formal application whereby we can formally respond. But the court is found conservation, having determined that issue.
So I think maybe we need to make a formal application with regard to that.
Yes, sir. Okay, Your Honor.
You can file an application.
It's all right, Your Honor.
The other side. You can respond.
Okay, much obliged, Your Honor.
But for the wallet, you said you have no objection.
No, we do not have.
So the same to be released to the fourth respondent through the IO.
Most obliged.
we had another matter for mention.